Hi, everyone. Thank you for joining us today for Constangy's webinar, Legal Labyrinths, Charting a Course Through State Non-Compete Laws. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is approved for SHRM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get those. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. I'm now going to turn it over to today's presenters, Jackie and Dave.
Good afternoon, everybody. My name is Jackie Johnson. I'm a partner in Constangy's Dallas office, and I co-chair Constangy's Trade Secrets and Unfair Competition Practice Group. Non-competes and everything unfair competition have pretty much been my subject matter of expertise for the last couple of decades, and I'm looking forward to talking to you about developments in this area.
Nice meeting everybody. I'm Dave Kurtz. I'm the head of our Boston office and also chair the firm's litigation department, and spend a lot of time like Jackie dealing with restrictive covenant issues of all sorts all across the country. And in fact, I know that some of you on this call are people who have worked with on those very issues. We received a comment that the sound may have had a bit of a reverb. Hopefully it is fixed at this point, but if anybody's having sound issues, let us know in the chat, and we'll do our best to work on that.
So it all started with a sandwich, and I would, like to say that I haven't been practicing law as long as I have, but I have. So I can tell you that it used to be the case when I would try to do a non-compete update that there was very little to talk about, and I would have to scratch the bottom of the barrel to come up with some content for any kind of update like this. The Jimmy John's kerfuffle really changed that. And what happened in Jimmy John's was in 2014, and I don't know if everyone's familiar with this, but it's a sandwich chain. And an employee of Jimmy John's leaked onto the internet where all things, are discovered, a copy of a non-compete that Jimmy John's made everyone sign, including their sandwich makers and delivery drivers. And it caused kind of a large uproar because of, the obvious concerns about why does Jimmy John's care if one of their people that assembles the sandwich goes to work for a competitor. And so the backlash on that was strong. I can tell you that, I just actually added up before this presentation today the number of state statutes that were enacted after the Jimmy John's uproar, and it's 12. And as we're going to talk about, that created the Jimmy John's and the perception that non-competes were being overused and used with lower wage employees. They created themes in the statutes that have come into an effect after the Jimmy John's. And as I said, there are 12. Do you want to new statutes? So the immediate backlash for Jimmy John's as it pertains to that sandwich company was that they stopped using the non-competes. They 86 them, and if you're familiar with the restaurant industry, that means you take something off the menu. But and the AG of Illinois actually pursued suit against Jimmy John's, as well as a number of class actions were filed. Again, outrage and a lot of backlash, which led to a number of the state statutes we're going to talk about today. The agenda as that I'm going to set forth, and I said earlier, as far as what Jimmy John's, the aftermath, so to speak, was wage thresholds. Notice requirements was not something really at issue in the Jimmy John's situation, but have become a recurrent theme in the new state statutes. largely because of perceived perceptions of fairness that non-compete shouldn't be sprung on employees on their first day of work, or, that they know about it knowingly going into a situation that they're going to have to sign restricted covenants. Prohibitions as to certain types of positions, and this goes to the kind of ties into the wage thresholds and the idea that the employer should have a legitimate interest to be protected at the end of the day in whatever, for the positions that they're having to sign non-competes. Confidentiality provisions too is something we're going to talk about, and that used to be honestly kind of a no-brainer of companies thinking, of course I can have confidentiality provisions with my employees, but they too have become something that have faced more heightened scrutiny.
Yeah, it used to be the case that when you're going to pretty much any state, you're looking at how long is the non-compete. So is it geographically, is it reasonable from a temporal perspective? Is it geographically reasonable based on the position? Certain positions that you may want a certain number of miles, others, maybe you can make an argument that they're nationwide, and what do they cover? That was pretty much the issue everywhere. You'd look at whether there was adequate consideration. Some states will say that continuing employment is sufficient consideration for non-compete. Some won't. But despite the fact that it was generally a patchwork of law, you were looking at the same general things everywhere. Jimmy John's comes along, and the states took notice of this. And now we have this patchwork that we're going to go through nationwide, and you really have to know what's going on in a particular state to know whether you can, what you have to put in your non-compete, whether you can enforce it. And it gets really confusing because, like most employers, if you're an employer that has people in multiple states, including border states, you may have a different law that's governing you across the street. So it's become very, very challenging. And so on to the issue of wage thresholds. The wage threshold madness, as we put it, is a little bit of madness because there's oftentimes no rhyme or reason when it comes to what the amount should be. There's no magic amount that makes somebody more worthy of a non-compete than others. But to give you an idea, Maryland has a non-compete wage threshold of $15 an hour, $31,200 annually. And if you meet that threshold, which is going up later in the year, you can have a non-compete. Washington, D.C., you can, some places look across the street into Washington, D.C. from Maryland, it jumps by 5 times up to 150,000 or, 250,000 for medical specialists. Then you look down on the other side of DC and you look into Virginia and you're talking about this fluid average weekly rate, which for 2023 is $69,836. I think one of the overall messages here, and this is something that we've always shared with our clients when we're looking at non-competes, is judges are human, most of them. And when you're walking into court and you're trying to enforce a non-compete against somebody, if you have somebody who is a relatively low earner, then the judge is thinking, even if there's no requirement in a certain state, the judge is thinking to themselves, do I really want to block this person from their profession, given that they make $50,000 a year, for example? Whereas on the other hand, if you come in with somebody who is an executive, a high earner, making into the 6 figures, the mid 6 figures, whatever the number may be, then the judge is saying, okay, this is the kind of person who I can understand why this company has a reason to try to put a non-compete in place. So it's a lot of this, in some ways, it's legislating a lot of the common sense decisions which have come down by judges for years. Jackie, I know you like this map. It gives us an idea of what we're talking about when we're dealing with Maryland, Virginia, and that little red.
I mean,
district.
You said it best, literally across the street. But when you look at DC, it's a little red, squarey thing right in the middle. And then you've got Maryland and Virginia right there, the madness, right? DC's statute's interesting because it recognizes inherently the issues about where it's located, the size of the city, and the amount of employee mobility that goes back and forth across state borders for people that actually work in DC, right? And it says that essentially, if an employee lives outside of DC but spends more than 50% of their working time in DC, the DC statute applies to them. And so it can be, adding to the patchwork is, just trying to have your hands around as an employer, how much time, for instance, employees are spending in a state. Particularly now, we've got remote employees all over the place for a lot of employers. So it is madness in my mind. So.
Yeah, and that issue when it comes to remote employees is very complex. From a choice of law perspective, we have these discussions with our clients all the time. We have an employee who lives in one state, but they're working into another state. We get into the analysis of how often they actually go into the office in the other state, if at all. We have to look at what the laws say in both states or in multiple states sometimes. Sometimes there are laws that we'll talk about that limit the choice of law of another state. So as the proliferation of statutes have come into play with respect to non-competes, it's become harder to navigate, but it also it provides some choice and it provides some reason to engage in analysis. And sometimes you're saying, okay, this is, when it comes to this employee, to try to put an effective and enforceable non-compete in place, this is the law we're going to choose. This is how we're going to structure it. And these discussions early on, and sometimes given the notice requirements we're about to talk about, be well in advance of somebody starting, they're important to engage in. And so notice requirements. I know this is another favorite of yours, Jackie.
I have, I assist a number of clients with their multi-state restricted covenant programs, both in drafting the actual agreements and keeping them up to date, but also kind of wrangling with things like notice requirements. And when you've got, a state saying different things about how much notice and where the notice has to be, it can create a lot of headache. Some clients have gone as far, honestly, as saying that they're putting into their job postings the requirement that a restricted covenant agreement, including a non-compete, be signed, so that's obviously the earliest in a process as far as someone onboarding with a company, being recruited by a company, and they certainly can't say later on that they didn't have notice. These notice requirement, again, as Dave was saying, as far as putting into a statute some of the common sense things that judges take into consideration. Injunctive relief is equitable. At the end of the day, it is within a court's discretion whether or not to issue it. And, the law is one thing, and then there is the facts on the other. And in between those two places, the law and the facts, there's a lot of room for a court to hang their hat on something like, well, the employee didn't know about the non-compete until they started work. And, they moved across country and gave away their dogs, sold their house, pulled their kids out of school, their wife left a job, right? And that was actually some of the facts from one of my cases. So, I mean, it is something that, I encourage clients to be, more notice than less, having it multiple places. Obviously, you get some tension between your recruiters potentially about, we don't want to scare away candidates. And obviously get that, but at some point in the process, you've got an employer has to decide, well, if I'm going to scare away this candidate because they have to sign a non-compete, is that someone I want to work with me in a sensitive position and have access to my clients and confidential information? So,
yeah, and you've got to get these notice requirements right. I had a matter where a client did everything right with respect to the non-compete, had it drafted properly, had all the proper legal elements in it for this given state. And it turns out that somebody executed the offer letter maybe an hour before the non-compete was issued. Somebody who got an offer letter said, great, I love this job, I'm going to sign this immediately, and then gets the non-compete. Turns out that this person loved signing the letter and taking the job right away, but decided to leave not that long thereafter. We wanted to enforce the non-compete, and somebody went back and said, let's talk about the notice requirements, and you can't do it because you didn't issue this at the right time. And sure enough, the lawyer on the other side was correct. And so these timing requirements can have major implications. And again, it's hard when you're a multi-state employer and you're trying to keep up with these. It's challenging, but it's something that you have to do. And meeting the elements of these notice requirements is crucial. Also, frankly, if there's a benefit to all of this, and sometimes you want to look at the benefits. If somebody is coming on board and they know this is coming, and they take the job anyway, and they've been given a full opportunity to consider the impact that it would have on their career and whether it was something they wanted, it takes away a lot of the arguments that we sometimes see, which is that, well, this was thrown at me on the day I was signing the documents. I was under duress. I was clicking through everything. So getting some notice of this and being able to say that both to the employee's lawyers, to a judge, to an arbitrator, whoever it may be, it's a good thing. And so we've always generally provided the requirement that we've always given the advice that you want to give some notice to the extent possible, and there's a good reason for it. So we had a question. We have a couple of questions here. Can an employee waive the notice requirement? No, I mean, generally these laws are set up so that you have to provide the notice in advance. And if you do not give the notice in advance, it's unenforceable. Now, somebody could have a non-compete, not raise this issue, and decide to abide by it, or maybe the issue never gets raised to a judge. But in terms of being able to waive it up front, these are requirements that you have to comply with. And then there's another question here, Jackie, if you want to take this one. It's are the notice requirements based on residence or work location?
And yeah, that's going to depend on the particular statute at issue and how the statute defines who's covered by it. As a general matter, when it comes to the laws on restricted covenants, most states take the position that the public policy of the state in which an individual resides trumps any other state law. And so you would typically look at the state where the employee resides. That's not always the case. Like I talked about when it came to Washington, D.C. statute, where it, through its statute, has that statute encompassing employees that spend more than 50% of their time working in that state. As far as the notice requirement, I don't know. None of the states that have the notice requirement have anything funky like I just said about DC, but typically it would be the state in which the employee resides. Although, as David noted before, if an employee is spending most of their working time in a different state, then the most conservative best practice would be just go ahead and give them the notice, right? Because you don't want to inadvertently screw it up, because the consequences are your non-compete's not enforced.
There's a question about the Colorado law. The Colorado law, when it comes to notices, it requires a separate writing. And so there's a question about whether that can be addressed in the offer letter itself. It requires a separate writing. I think they can be sent at the same time, but you have to have a separate document that's signed by the employee that acknowledges that they're going to be bound by a non-compete. And so this is prohibitions as to certain positions has always been part of the law. There's always been in some states restrictions on, for example, physicians. Massachusetts, you can't have non-competes with physicians. In some states, there's been a lot of states in the broadcast industry, which has a unique history, but broadcasters couldn't be subject to non-competes. They could move from, one television station to the next. But this is part of the continuing trend in terms of trying to find ways to make the non-compete world narrower. So not allowing non-competes for interns in Massachusetts, not allowing non-competes for hourly or non-exempt employees. So this is something that's always been in place, but it's a growing trend in connection with new laws that are being promulgated.
I would just note that the prohibition against non-competes with attorneys is something that I have friends ask me all the time. Well, you talk about non-competes all the time. Are you subject to a non-compete? I'm like, oh no, attorneys cannot be subject to non-competes. And they laugh and like, well, that's pretty self-interested that the attorneys would advocate for statutes that preclude them from having non-competes. But that restriction is based on essentially the notion that clients of attorneys should be able to follow their attorney wherever they go because of the special nature of the relationship and attorney-client privilege and the trust and counseling kind of relationship between that. But then I turn to like the physician-based restrictions in certain state statutes, and like Texas, physicians are allowed to buy themselves out of the non-compete, right? And that's the restriction. It's that you have to have a buyout provision, but otherwise you can place non-competes on a physician. So I'm like, well, the patient-physician relationship's pretty special too. So it's just an example of how there's just some inconsistencies as far as what the statutes provide, what interests they're trying to protect, and sometimes it just doesn't seem consistent at all.
Yeah, the attorney one is especially interesting because the ethical rules governing attorneys say it exists in almost every state where it says attorneys are ethically barred from entering into an agreement that will have that would prevent them from, or in any way limit them from the practice of law. And so the question has come up a lot. Well, okay, we understand what that means when it comes to an attorney who is at a law firm representing clients, but what does it mean for somebody who's in-house? A lot of the people on this call who have a internal business position, really. I mean, it's an attorney, it's a counsel position, but it's a business position. And these ethical rules, it's not so much the state statute. What happens is somebody comes in and says, you can't enforce this non-compete because I was void from entering into it as a matter of public policy under the ethical rules governing lawyers. There's a whole body of case law on that. So it's a really interesting topic.
Yeah, and it becomes kind of a difficult decision if you take it to the next step, which is if you're an employer and you want to say I can have non-competes with my in-house counsel because they function more as a business person, are you jeopardizing then the attorney-client relationship and the confidentiality of their communications and work product? If on the one hand you're saying, oh, they're a business partner, and then you're saying, oh, but no, they're our in-house counsel and that's all privileged. So it's a decision whether or not to use them with in-house counsel that needs to be thought through.
There was a question raised in the chat that we have about whether we recommend advance notice for items like client non-solicits and employee non-solicits. This is actually a very timely question. It's an interesting question. So the new Colorado law, when they look at when they're defining non-competes and they're exempting certain restrictive covenants from the bar, they specifically mention customer non-solicits. And so under their law, although it's not crystal clear, we take the position that the advance notice requirements, not only in Colorado, for example, not only apply to straight non-competes, but they also apply to customer non-solicitation provisions. As a general matter, we've always had these conversations of, okay, you've got your non-compete and you have your non-solicits, and they sit in separate buckets. And maybe you want to not have a non-compete, but you can have those non-solicits. What we'll tell you is, number one, there's been more of a focus, especially on customer non-solicitation provisions, and whether those in essence operate like non-competes, number one. And number two, the idea of trying to provide advance notice when it comes to restrictive covenants, that's also something which there's been a closer look, as we talked about with Colorado, of including non-solicitation provisions as well. I think as a general matter, of course, if you're providing advance notice with respect to a restrictive covenant agreement, it's a good practice to mention all of the restrictive covenants. You're going to be subject to a non-compete, customer/client, employee non-solicitation provisions, and confidentiality provisions.
And just to add to that a little bit, and when it gets to customer restrictions, often a customer restriction is drafted to be more than just a non-solicit, right? It can be, you will not accept business from. And then, there may be ultimately a dispute is because of the breadth of the customer-based restriction, is it actually a non-compete as opposed to just a non-solicitation provision? And those kind of questions, would warrant, well, why don't we go ahead and give notice of the non-solicit, just in case it's construed as something broader and put into the non-compete bucket.
So the joy of the non-compete road trip. So you get your convertible with the top down, and what could be better than going state to state, finding out what the non-compete landscape is in those various places?
Well, having just gotten back from a road trip that ended a day early because everyone decided they'd had enough, I'm sure that once we go through all these state non-compete statutes, some of our attendees may want to go, enough, this is too much.
Well, let's start with in some ways the easiest, right? Which is California. So I mentioned at the inception of this, I'm the head of our Boston office, but I'm also a proud member of the California bar, having taken the bar exam after more than 20 years of practice a few years ago, because the laws are so employee friendly in California that I wanted to make sure I could fully practice law out there. So as I think most people know, outside of the context of the sale of a business, non-competes are unlawful in California. Customer/client non-solicitation provisions are also unlawful in California as a matter of public policy. For a long time, we were advising clients that, you can't have those things, but you can have an employee non-solicit. So at least you can bring somebody in and tell them that they can't solicit your employees. In recent years, there have been some decisions that have come down which have led to questions about that idea as well. The California Supreme Court has not weighed in on it yet, and many employers are still choosing to have employee non-solicits for the time being. But I think everybody should know that there's at least some risk that they will not be enforced. And if we had to guess, there will probably eventually be a decision that holds that employee non-solicits, from the highest court of the state. We expect the decision will ultimately come down and say that employee non-solicits are also void as a matter of public policy. The California Attorney General's office is interested in this topic, and they're not afraid to go after employers who have unlawful provisions in their contracts. I get the question a lot. Well, all right, we know it's not going to be enforceable, but let's just put it down on the paper and it has the interim effect. And somebody will say, okay, I have a non-compete, even though we know we can't enforce it. And that's the kind of thing that the AG's office is not happy about. Also, if you knowingly put an unlawful non-compete in an agreement in California, there is the risk. So let's say it's in an employment agreement with other types of provisions. It has including confidentiality provisions. It runs the risk of voiding the entire agreement. So it's a dangerous thing to do. The other question we get a lot is, can you write around it by having an out-of-state venue provision or choosing, Delaware law? A lot of Delaware corporations have operations in California. So can we choose Delaware law? California law is actually focused on that too. If there's a section of the labor code that says that you cannot have an out-of-state venue or choice of law provision unless the employee is expressly represented by their own personal legal counsel in negotiating the agreement and agrees upon that. And if you otherwise choose one of those out-of-state, if you choose an out-of-state choice of law provision or a venue, it's voidable by the employee at the employee's choice. So California, when it comes to restrictive covenants, you can have strong, robust trade secret protections. But when it comes to non-competes, they remain a no-no. So Colorado, which is where Jackie's vacation that ended prematurely was.
Don't let 14-year-olds guide the hiking part of a trip. That's all I have to say about that. The wage thresholds. Okay, so Colorado, like a couple of other statutes that we're going to talk about, Illinois being one of them, has one wage threshold for non-competes and then a reduced wage threshold for non-solicits, which intellectually to me doesn't make much sense. From the standpoint of employers' interest in protecting their clients, why there should be a wage threshold that's attached to just keeping your employees away from your clients post-employment. It's not a limitation on working generally. You can still go to work from competitors. You can just leave our clients alone. But Colorado, Illinois, and I believe Washington State have been taking the position that there's two different wage thresholds. So it's not, to me, intellectually consistent, but it is what it is. Colorado is unique in that it has criminal penalties associated for violating the state statute. For persons, a person who violates this section can be found guilty of a class 2 misdemeanor, spend up to 120 days in jail, and or be fined $750. I would take the $750 fine if the choice was 120 days in jail. That seems like quite a long time for having someone sign a non-compete. But this is just another example how the states are trying to put teeth into their statutes. So it's not to prevent employers from kind of taking the position, well, I'm just going to use them anyway. And if it's not ultimately enforceable, so be it. That there's going to be a lot more at issue than just the unenforceability of the agreement. Colorado statute also has limitations on non-disclosures, which some of these limitations kind of were generally found in case law anyway, that there's no essential protectable interest in general knowledge and training of employees, that they have the right to use those types of their general skills and knowledge to go out and work after they leave you. But Colorado has incorporated that into their statute as far as limitations on non-disclosure provisions.
And Jackie, before you turn to Illinois, so we had a question that I think is a general one. It was, are non-competes during employment only not permitted in California? You can have a non-compete that binds employees during the course of their employment. What the public policy is about is post-employment non-competes. And by the way, that's the case everywhere. So these laws that are dealing with non-competes are talking about non-competes which would restrict somebody from competing against you when they leave. While somebody is working for you, you can certainly restrict them. Not only can you restrict people from working for a competitor, but generally there are absent states with moonlighting statutes, and we're not going to go too far afield here, but you can generally say, look, you have to work full-time for us and only for us during the course of your employment. So we're talking about non-competes, we're talking about post-employment non-competes.
Right. And with respect to the question that was specific as to, non-competes in California, California is one of the states that has employers cannot have anti-moonlighting policies. So if you were going to have a non-compete that's phrased as only existing during employment, it should be phrased like a non-compete and not like you can't work anywhere else. But I'm only adding that because California, that is a specific issue.
Yep.
So Illinois. So Illinois is interesting because Illinois came out of the gate post Jimmy John's with a wage threshold of $13 an hour. That was the statute that it passed originally in 2016, which is fairly low, obviously, compared to what we have now, which is $75,000 for the non-compete and 45 for the non-solicit. As noted, Illinois looked prospectively in the future and said then we don't have to update this all the time. So the statute takes care of stair steps, and those wage thresholds are increased by $5,000 for the non-compete and $2,500 for the non-solicit every 5 years, and it's all set forth in the statute. You may ask, like, how do you deal with that as an employer when you're looking at you're drafting your agreement and trying to figure out how can I project with my magic 8-ball how much a particular employee is going to be making in whatever year, right? Maybe they were meeting the threshold in this year, but they're not meeting the threshold in 8 years down the road, right? And like there's an actual civil penalty associated with the Illinois statute, $5,000 or $10,000. What I've advised clients to do is to, and it is not necessarily, the most eloquent of ways of doing it, but it's the only way I can figure out that can take care of this issue is, when you have a state agreement for Illinois, or you have a appendix to your agreement that takes all the state oddities into consideration, that you say this only applies to employees that are making X threshold as defined by the Illinois statute, whatever, so that you're not inadvertently having someone sign something that ultimately isn't enforceable because their compensation doesn't keep up with the threshold. It's kind of clunky, but it's I think the best solution for trying to make sure your agreements keep up with whatever compensation your employees are making.
Continuing on the road trip.
Road trip. Louisiana is always a fun place for a road trip, but not a fun place for non-competes. Louisiana has a statute that says that the geographic scope of a non-compete must be defined by reference to specifically named parishes within Louisiana and counties outside of Louisiana. And it's not, and the case laws that has interpreted that requirement has in almost all the courts in Louisiana been interpreted to mean you can't just say all the parishes in Louisiana or all the parishes within a 10-mile radius of the workplace. You have to actually say, Baton Rouge Parish or whatever the parish's name is. And most of the parishes I can't pronounce because it's Louisiana, but you'd have to actually put the name of the parish and then the counties outside of Louisiana if you want a restriction that goes beyond the state. This is such an unwieldy requirement. particularly if you have a high-level executive working in Louisiana that has national duties and you want to have a non-compete that's nationwide in scope. I do have it. I have the list of every county and every parish in Louisiana and outside of Louisiana within the United States that when necessary for the right, level of executive that has national duties, will, slap that list onto the non-compete. But it is certainly not something that the statute has not been updated since it was enacted. It predates essentially the internet. So at the time it was enacted, I think that the thought process was, employees cannot readily ascertain what parishes might be at issue. If you say all the parishes within 50 miles of New Orleans or whatever, they may not know that, and they may not be able to figure that out. Obviously you can figure that out really, really easily now, but when the statute and most of the case law in Louisiana has not kept up with that. I'm saying most because there's a renegade state circuit court, the Third Circuit in Louisiana, that has taken the position, if you can readily ascertain the parishes and counties at issue, that's sufficient, which is pretty much, what I think a modern take on, geographic restrictions would be, which is, can you figure it out? Great. Check that box. But that Third Circuit is an outlier, and Louisiana Supreme Court hasn't ruled on the issue. So a majority of places in Louisiana, you got to name them by name. And then in the Third Circuit, Louisiana State Third Circuit, it's sufficient if they're readily ascertainable.
And by the way, a question came in about whether moonlighting is permitted just for managers or other employees. I think this is probably a state statute issue. Certain states may have limitations on the right of somebody to moonlight, others may not. So it's a bit of a complex issue. We're happy to talk about that topic offline. Georgia. One of the interesting things about non-competes is that non-compete law, in some ways, it doesn't necessarily line up with what you would always think of as employee-friendly states and employer-friendly states. In fact, some of the states that bar non-competes altogether, like Oklahoma and North Dakota, nobody's generally thinking of them as employee-friendly states, but that's where they fit in the landscape. So the Georgia appeals court, the Court of Appeals last month issued a ruling with respect to employee non-solicits in Georgia, and said, so the law is in Georgia, you have to, like we talked about at the inception, this is generally the case, is that you have to have when you're talking about a restrictive covenant, it has to be reasonable from, among other things, a geographic scope. And you have to explicitly, and what the court says, you have to explicitly put in some geographic restriction, even when it comes to an employee non-solicit. And I'll tell you, that is generally not something which has traditionally been tied to an employee non-solicit. If you say you can't solicit our employees, there's generally no geographic tie to it. But in Georgia, that's something you now have to do. Now, what's interesting about that is it doesn't mean you have to say within a 25-mile radius of Atlanta, for example. You can say anywhere in North America, because of the nature of the person's role in the business. You have to be able to justify the geographic limitations, but you got to put something in there for an employee non-solicit now to be viable in Georgia.
That Georgia case was very interesting too, because Georgia used to be very, very anti-enforcement of non-competes and customer non-solicits. It was like you had to write the perfect agreement to get it enforced. And then they went the opposite direction with a state statute that was pro-enforcement and allowed courts to reform overly broad restrictions, and had some presumptions that if you had language that kind of was close to this language, then that worked, and all this kind of stuff. And then the Georgia case said, well, that statute only applies to non-competes and customer non-solicits. It doesn't say anything about employee non-solicits. So we're going to back up and go to essentially the law beforehand, which was very anti-enforcement. I'm like, and we're not going to reform it. We're going to just throw the agreement in the trash. So it was a kind of a crazy outcome to me, given the history of Georgia law.
I don't think we have a big main contingent on the phone, but like a lot of states, they've created a wage threshold. So it's 400% of the poverty level before somebody can be subject to a non-compete. They have to earn at least that, the 58,320. They have a notice requirement prior to receiving a formal offer of employment. So, hey, informally, you're going to have to sign a non-compete. Now here's our formal offer. And this is an interesting one. It can't take effect until there's been at least 1 year of employment or 6 months from the date the agreement is signed, whichever is later. So the idea behind that is if somebody comes in, they work for you for a month, either side decides, you know what, this isn't working out, that employee can't be subject to a non-compete. So there has to be some minimum service requirement. And that's something which other states have looked at as well. And then Maryland, crabs. They have, you know, it's the state with the low, it has a wage threshold. It's the lowest so far, but it is going up later in the year. And Massachusetts, which is my home state. So Massachusetts passed a robust non-compete law several years ago. Before that, it was really just a patchwork of case law. And so, like a lot of states, there's now a notice requirement, a 10 business day notice requirement. One of the big pieces of confusion in Massachusetts is when the statute came out, everybody said, okay, the law requires that you give garden leave as consideration for the non-compete. And the garden leave would mean when somebody leaves their job, while they're sitting on the bench, you have to pay them some percentage of, that's generally what garden leave means, is you continue to pay somebody something while they're forced not to compete against you. Actually, the Massachusetts case law has come down and has focused on this other reasonable consideration piece. You don't have to give garden leave in Massachusetts, but you do have to give some kind of consideration to support the non-compete. There's a big one. If you terminate somebody without cause, you can't enforce the non-compete in Massachusetts. There's a 1 year limit on the post-employment restriction. And then, like some of the other states we've discussed, there's a limitation on certain positions and certain types of employees in terms of who can be imposed who can have a non-compete imposed against them. A couple of questions that have come up as we continue the road trip. One is, you know, do any of these statutes recognize differences for non-competes in the context of an employee equity ownership plan? Jackie, I think the answer is no to that.
So the only thing about the employee equity ownership plan is that typically those would not be a condition of employment. They would be something that an employee would, you know, accept as a benefit and then agree to, which does have some implications in a limited number of states. Like the California limitation on choice of law provisions only applies to agreements that are a condition of employment. So you arguably you might be able to, with respect to a California employee with an employee equity owned agreement, use a choice of law because that would be not a condition of employment because something's separate. And then there is, and Dave is going to talk about New York in a bit, but there's some case law in New York that if you've got a non-compete baked into an agreement that is not a condition of employment, but is more associated with a benefit like equity or employee ownership of the company, that courts shouldn't really get in the business of scrutinizing how reasonable those restrictions are, because it's more of a transaction. Like, okay, well, employee could say, no, I don't want to own any of this business. No, I don't want this equity. I don't whatever. And I'm not going to be subject to the non-compete because I'm not going to sign the agreement, and I can still be employed. I can still work for you. And so it gets to the level of scrutiny that a court, but by and large, if you look at all this, the wage thresholds we've been talking about and the notice requirements we've been talking about, whatever, those state statutes are not delving into, what type of agreement necessarily it's associated with, leaving aside sale of business, which we're not talking about today. We're talking about, employment context, non-competes, but.
Yeah, and by the way, if you own a small amount of stock in a company and then the company is sold and we try to say, well, hey, it's a sale of a business non-compete, the courts have said, yeah, that doesn't work. Just because you got some payout for owning stock in a business, that doesn't turn it into a sale of a business non-compete. We had a question about non-disparagement clauses, and we've got some more to go through on this, but real quickly, a non-disparagement clause is also a restrictive covenant. Can you enter into them? Sure. They're actually increasing restrictions on non-disparagement clauses. California was mentioned in our question. California recently passed a new statute about when you have a non-disparagement clause, for example, in a separation agreement, you have to have some limitations that allow people to talk about certain violations of law, and it can't block them from doing that. That is a growing trend. So generally, you can still have non-disparagement clauses. There are increasing limitations on what you can have. Non-disparagement clauses are hard to enforce. And remember, you have to go in the court generally and say, this is what this person said about us. And you have to decide whether you want to publicize that. So it's that's the kind of discussion we have all the time. All right,
Nevada is notable because it has essentially a carve out that would allow an employee to do business with a customer, leaving aside the presence of a customer non-solicitation provision, as long as the employee did not actively solicit the customer and the customer sought the employee out, right? Which from most sales context non-compete situations, you've got customers that are contacting a salesperson directly, usually on a cell phone, whatnot, and it creates a very easy situation where a client calls up an employee and says, I need whatever, and the employee says, well, I'm no longer with that company. I'm like, I don't care where you're with, I just need whatever it is, right? But that's the situation in Nevada. Also, no non-competes if they're paid slowly on hourly, exclusive tips or gratuities. So that's Nevada in a nutshell. New Hampshire,
live free or die, 200% of the federal minimum wage in order to bind somebody by a non-compete. There's a notice requirement. You have to give notice, but the law doesn't say how much notice you actually have to give, which in some ways is classic New Hampshire.
New Hampshire was the first state that had a notice requirement though, but then they just essentially said some notice, which why bother? I mean,
what's reasonable under the circumstances? Is it 5 minutes? Is it 5 hours? That's probably the kind of thing that will be litigated at some point, but there's not a lot of case law on non-competes in New Hampshire. And so, open question. Minnesota just passed a new statutory ban on post-employment non-competes. The question always comes up when these new laws come up. Well, what about existing non-competes? Do our existing non-competes stay in place? And the Minnesota law specifically says, hey, this law applies to agreements on or after July 1, 2023. If you have one in existence, then you're going to be judged by the old standard. So something to keep in mind.
It also explicitly doesn't apply to non-disclosure agreements and client or customer non-solicitation provisions. So it's just limited to true geographically based non-competes.
New York, the Empire State, there's been a lot of questions about what's going on with New York. The governor of New York has had a bill on her desk for a couple months now, at least more than a month, saying ban non-competes entirely. Hasn't been signed yet, and I can tell you that there's been a deluge of lawyers and business people talking to the governor's people legal counsel and others and Department of Labor. And so there's a reason why this bill has not been signed yet. The hope is that maybe it will go back to the legislature and they'll make another shot at coming up with something more reasonable. But that's kind of happening in the back rooms right now. And obviously it's a heavily political issue. So it's going to remain in the back rooms because the governor and her team don't want to go out there saying, well, we support non-compete. So we'll have to see what happens with that. One thing that's here is there's this issue that comes up a lot about in New York is, hey, if you terminate somebody without cause, is the non-compete automatically unenforceable? Jackie and I were talking about this yesterday. It's sort of a misconception. There's a doctrine called the employee choice doctrine, which in essence says, hey, if somebody chooses to give up something in exchange for a non-compete, then you don't need to get into the reasonableness of the non-compete. What the law really says is that if you terminate somebody without cause, then you're supposed to go into a reasonableness analysis as to whether the non-compete should be enforced or not. So there's been some cases that have actually gotten this wrong by the federal court. So it's an issue that we would advise you when you have these situations, you talk to counsel about. North Dakota and Oklahoma, pretty straightforward. You can't have non-competes in those states, although Jackie, non-solicits.
So the Oklahoma statute says you can have a prohibition against the direct solicitation of established customers of the business. So obviously it's not prospective customers, it's established customers. It's not, you cannot directly or indirectly. I mean, in Oklahoma, you cannot directly solicit. And, used to be that we were like, oh, okay, well, Oklahoma, there was case law that courts would judicially reform and, just strike it out if it didn't work and whatnot. But the case law has been more limiting more recently as far as courts not deciding just to strike out a non-compete and just, essentially rendering the whole thing kaput. So it's, again, strikingly odd that North Dakota and Oklahoma care about such things, but they do. So Nebraska, Dave and I were talking about this too. There is case law in Nebraska that seems to suggest that non-competes are a thing. But then when you actually look at the case law, you can't find any non-competes that have been enforced. That they've all pretty much limited to customer-based restrictions. And the problem with, kind of pushing the envelope and saying, well, I'm going to try for this non-compete. There's cases that say non-competes are enforceable if they're tied to legitimate interest or whatever. And why not throw it in? Is that Nebraska is an all or nothing state. I mean, it is one of the states that will literally throw your entire agreement in the trash if anything offends the state law. So, and that just brings me generally to just note something that we haven't explicitly talked about, which is knowing the state law on reformation is really important when you're drafting agreements and deciding whether to be conservative or, to just kind of throw it all in there and see what works, right? Because there's essentially three buckets. There's the all or nothing states like Nebraska, right? Where you're going to throw the whole thing in the trash. There's the other end of the spectrum, where courts, like in Texas, can pick up a pen and rewrite the whole thing, right? And put geographic limitations in there that might exist, might not exist, limit them, whatever. And then there's states that can just take a pen and start striking through things. And knowing how a state approaches reformation is really important in deciding, how conservative or aggressive to be when it comes to restrictive covenants.
Yeah, you'll often hear the terms red pencil state, which is the all or nothing, blue pencil state, which means, hey, if I can cross out for a piece of this and keep it alive, then I will. And then there's the reformation states, which the court has the right to rewrite it entirely. So we're getting close to time, and just to skip through this a little bit, people should be aware Washington is a challenging state on non-compete enforcement. Washington, D.C. is a new law. Everybody's probably thinking to themselves, okay, we're talking all about state law, and what about the Federal Trade Commission, and what about the National Labor Relations Board and the Department of Labor, and all these federal efforts to put into place non-compete legislation and bar them all together. It's all happening, but you can rest assured that there will be challenges. And even if, and there's a lot of work and a lot of employment lawyers, Jackie and I are two of them, have tried to work with the federal agencies to try to talk some sense into them in terms of putting some limitations on the legislation. But we expect some rules to come down, and then we expect immediate constitutional challenges. We expect that the laws will likely be immediately blocked when they come into place. We expect that this will likely end up back at the Supreme Court, sort of like some of the COVID vaccination legislation. And we also anticipate that the court will strike down the rulemaking the rulemaking that takes place. So I don't count on that. And we don't know what will happen. There's no guarantees of anything, but one guarantee is that there will likely be rules that will come out on a federal level. And we would expect that there will be significant challenges when that happens.
There was one question about the FTC and is it a law already, or what is the situation there? It's a proposed rule, and then it was open for comments, which is and then an extended period for comments, which is part of what Dave referred to as like he and I joining together to provide the FTC with some written thoughts on what we think about the ban on non-competes. So it's my understanding that the materials are going to be distributed after the session concludes. Feel free, obviously, if you want to reach out to either me or Dave, jjohnson@constangy.com, dkurtz@constangy.com. After this, we're happy to talk offline and make sure that we help you answer your questions.
Thank you. And here, for those who are looking for SHRM credit or HRCI credit, we're going to leave this up for a moment so that people can take down the numbers, but you also will get a copy of the presentation.
Thanks, everyone.
Thank you.